Be agreed to. I call the Honourable David Parker.
Thank you, Mr Speaker. Can I also concur with the Minister in the work that was done by the Select Committee under the good chairmanship of Chester Burrows, who I'm happy to attest to as a very effective chairman. Can I say why the Labour Party, with a somewhat heavy heart, is going to vote against this bill? Because 99% of what this bill will do in practice is good. 99% of the times when the powers in this bill to force a remand hearing or a bail hearing to be heard without the presence of the accused, there will be no injustice caused. But there is no need to take away the right of an accused to attend his or her trial. There is no need for that, and it is a fundamental right of me or anyone in this chamber or any other person accused of a crime to attend the trial at which they are being accused of a crime. And it seems to me such a fundamental right that I can't believe that we're so lightly brushing aside that right and saying that now it is a matter of discretion to a judge as to whether an accused has a right to be present at the trial where they're being accused of a crime. Accused, not necessarily guilty, accused. Now, I actually have faith in our judicial officers. We have a pretty benign political climate at the moment in terms of standing up for people's human rights. But it may not always be that way. And we will have the occasional judge who has a rush of blood to the head and thinks that this person's a terrible, evil person who ought to be put away. Maybe occasionally a former prosecutor who just aligns themselves a little bit too much with the prosecution. That happens. It does happen on occasions. It doesn't happen a lot, but it does happen. And in this bill, we are, for the first time in New Zealand's history, taking away your absolute right, or the accused's absolute right, to be present for their trial. And why is that important? Well, the sense of fairness, the sense of justice or injustice if you don't have the right to attend your trial will be ever held by the person who can't attend their trial when they want to. Forever they will think, well, what went down that I didn't see? Was the judge asleep? Did members of the jury fall asleep? Were faces being made at my expense when evidence was being called in my defence? Were inappropriate pictures being shared amongst the members of the jury that I didn't know about and therefore have a right to challenge? Those are just a few of the examples that I can think of as I stand here speaking. And the defendant or the accused will not necessarily know that that's happening, because even though they might have a video link into the prison where they're sitting in some little cell, assuming for the moment that we trust completely the corrections officers never to frustrate that process, which is a pretty big ask. I would think that at times I could foresee that process being abused at the prisoner end. But even if you assume that that end of the process is perfect, there's only one camera in the court. And that camera is only going to be looking at the witness or the lawyer. It won't be focused on the jury. It won't be focused on the other lawyers. It won't be focused on someone who might be up in the back rooms of the court holding up some sort of protest sign. This is outrageous legislation. Tonight we are taking away the right of an accused to to be present at his or her trial. And Mr. Minister, it's not the international norm. We were spun that by the officials from the department for a start, and when we dug into that, we found that that was very rare. There is the occasional exception starting to appear in some overseas jurisdictions. Most of them haven't done it, and those that have done it are wrong to have done it. There is no mischief here to be cured. We had no evidence at Select Committee that there was a problem here that needed to be fixed. We didn't have one instance where we could have it pointed to us that it was wrong that the accused had their right to appear at their own trial. Not one instance. And Minister, The minister is going to take away my and every other New Zealander's right to protect themselves against the actions of the state by appearing at their own defence. And it's now a matter of discretion for the judge. That is wrong. Now, what did others say? The New Zealand Law Society and the Human Rights Commission both submitted. They both submitted strongly, and they both said it was wrong. Now, given that there is no evidence of any malpractice or something going wrong here that needs to be fixed, why would the government override our existing civil liberties in the face of severe criticisms from both the Human Rights Commission and the New Zealand Law Society, and ignore those concerns and take away the accused's right to unconditionally be at their own trial? Now, if an accused acts up when they're in the trial and they disrupt the proceedings, the judge has already got rights of contempt to actually control the way in which the accused handles him or herself in court. And if that person is in contempt of court, they can be sent down to the cells. I've actually never seen that happen. I'm sure it happens occasionally. Judges do have the right to do that, so if there's something goes wrong in their court, they've already got the ability to control it. But it should not, there should never, in my opinion, there is no justification for taking away the right of the accused to be present at his or her trial. Sure, in the other 99 out of 100 cases where this will be used, where there is a bail hearing or where there's an adjournment because a witness isn't available so the trial can't proceed, or because the parties aren't ready, fine. I can accept that on those call-overs, on those non-substantive trial dates, that there should be the ability to override the will of the accused. It should be very slow for the judicial officer to exercise that discretion where the accused is opposed to it, but that discretion ought to exist. I agree with that. But for the substantive trial, where a person may be accused of murder, where their liberty is at stake, where their whole life, if you think about it, really is at stake as a consequence of a possible conviction, for the person not to have the right, the unconditional right to attend their own trial is just wrong. And what saddens me, or what perplexes me, is that I don't understand the problem that's meant to be being addressed by this, because there are no instances that we were given at Select Committee to show why this was necessary. I think that this is just bad policy that has arisen in the start by accident. I think the departmental officials thought that it was a good thing that we use technology to reduce court costs, to speed the costs of court procedures and to speed up trials, which is both of those are good objectives, because we shouldn't have long periods between people being charged and their eventual trial, and we shouldn't make these processes any more complex or expensive than they need to. And that was a good ambition. But their thinking was too woolly, because they didn't distinguish between call-overs and adjournments and bail hearings and the trial where someone is being accused of something for which they could be convicted and lose their liberty. And if the Crown is going to take away someone's liberty, then the person whose liberty is going to be taken away should be able to stand up at their trial and participate in every aspect of it. They should see everything that goes on. And if people in this court don't think that, and in this House of Parliament don't think that sometimes inappropriate things happen in court, well, I'm sad to say that you're wrong. They don't often happen, but they sometimes do. Whether it's witnesses behaving appropriately, or jurors behaving appropriately, or even occasionally judges behaving inappropriately. And if I was the accused, I would feel less able to protect my interests if I didn't have the right to be there. If I wasn't there, able to see those things when they go wrong and to protect my interests, I would feel an injustice. I would feel I wasn't properly able to protect myself against the power of the state. The state has all of the power and the resources here. They've got the police, they've got the prosecution service, they employ